The Supreme Court has reserved its verdict on the issue of recovery of AGR dues worth over rupees 40,000 crore rupees from telecom companies currently under bankruptcy. The top court's judgment will focus on three aspects in the AGR case. Number one would be how many years would telecom companies get to pay up AGR dues which they have to pay to Department of Telecommunications. DOT had agreed for a 20-year timeline, whereas Bharti, Airtel and Vodafone Idea had scaled down their demand to 15 years. However, the top court had remained insistent on securing payment of AGR dues by means of getting some security in return from telecom companies. The second aspect would be whether spectrum, or rather the right to use spectrum, can be transferred, assigned or sold under the IBC. And thirdly, if any additional liabilities are to be paid by telecom companies which are using spectrum initially allocated to other telecom companies, which means whether Reliance Jio or Bharti Airtel would be liable for payment of past dues of RCom, Videocon and Aircel, since Airtel had spectrum sharing and trading pacts with Videocon and Aircel, and Jio had spectrum sharing and trading agreements with RCom. The judgment of the top court is expected in the next 7 working days, since Justice Arun Mishra is going to retire on the 2nd of September. DOT had told the top court that no demand was raised against past dues of RCom and Videocon from Reliance Jio and Bharti Airtel, and the assessment of these past dues for the spectrum usage by different telecom companies is currently under progress. The top court had asked DOT that why demand was not yet raised despite nearly 10 months into the AGR ruling. Also, the court had clarified that DOT should cancel the license and spectrum if the dues risk being wiped out. The court had also hinted at cancelling spectrum allocation if the telecom companies are not ready to pay AGR dues. The court had made it clear that telecom companies cannot wipe out AGR dues and take someone else's property free of any liability, since the trading guidelines mandate clearing of pending dues by a seller before sale, and if a seller does not pay pending dues, trading guidelines transfer liability on the buyer. The banks, however, had told the top court to not decide on the resolution plan. They stated that resolution plan is something which is to be decided by the commercial wisdom of banks. They had cited a tripartite agreement with the President of India, which was relied upon to lend money to telecom companies. They had stated that the value of spectrum will diminish and banks will not lend if spectrum is not allowed as security, and telecom companies cannot operate without banks since they do not have pockets deep enough to buy spectrum. Lenders had urged the top court not to intervene in this matter, since they had claimed that economy will face a huge setback if spectrum sale is not allowed under IBC, since that will deter any future debts to be given to telecom companies by bankers, since they will not have any spectrum in terms of a security. It remains to be seen by when the top court verdict would come out, since this is being eagerly awaited not only by the telecom but also by the banking sector.